3, 2.
This month's case is sponsored by the letter D for due process. This is a Wyoming Supreme Court opinion decided in June of 2021 and involved a physician who was the subject of a 5-year suspension imposed by the board related to acts that were deemed to exploit her patient. The board also imposed costs, one half of the costs of the administrative proceedings plus a $15,000 fine were also imposed upon this respondent physician. Those issues were part of the subject of a reversal on appeal, but where we are going to focus today is on the due process argument made. So the facts of this case, in short, for compensation, the physician respondent assisted a patient with issues related to the operations of her ranch in Wyoming, ultimately terminated the professional relationship and continued on in the assistance of the operations of the ranch. She did all this, by the way, for compensation, ultimately leading to the investigation and administrative proceedings. These events took place back in 2014, and the patient ultimately soon thereafter passed away. The board order was officially entered in 2017, was the subject to an appeal and a remand, and then it ultimately the Supreme Court determined this, as I mentioned, in June of 2021. The issue of focus for us today is the due process rights, because what the respondent physician argued was that only 2 board members attended the 6-day hearing, which was put on in front of a hearing officer. And so obviously the board members either could or perhaps could not attend this. 2 board members did, and the other 4 did not attend this, but the other 4 attested to the fact that they watched the tapes and or read the transcripts prior to making the ultimate decision. It's a little bit hard to tell what happened procedurally, but I'm assuming the hearing officer made a recommendation to the board, which ultimately made its decision, findings of fact, conclusions of law, and imposed the sanction on that. The Supreme Court, by the way, upheld the sanction. It did reverse on issues related to the imposition of one half of the costs. But sticking to the topic at hand here is the participation of board members in the hearing by either attending or not attending. So the court went through its due process test analysis under a United States Supreme Court opinion where they addressed the private interest at stake, in this case a license, the risk of error and value of adding procedural safeguards, and whether or not the attendance or non-attendance and reading of the transcripts was sufficient, and then the government interest at stake, which is obviously public protection, consumer protection through the Enforcement of the Practice Act. Now, the statute allows for temporary board members to be appointed, and this is where the respondent physician argued that because of that temporary appointment process, that other board members should have been appointed and attended the hearing itself. In the end, going through the 3-prong analysis, the court determined that the due process rights were met and that the sanction could be upheld, the 5-year suspension. As I mentioned, some of the other issues were subject to reversal, but that 5-year suspension was upheld, and the due process rights were recognized under these circumstances. Now, another interesting point to this, and part of a distinguishing factor between additional cases, previous cases that were cited by the respondent, is the fact that there is a clear and convincing standard in Wyoming, a clear and convincing evidentiary standard, which helped distinguish some previous cases related to the application of due process rights. So this case is interesting, I think, for future analysis as to, 1, the procedural process that's followed, and then 2 is where due process can and should be met related to administrative proceedings. So bottom line in this particular case is non-attendance, but an attestation to reading the transcript is enough to meet the due process requirements of involvement by those board members. But this is a case that is interesting, I think, to the administrative community, and we will certainly keep an eye on future issues related to board member attendance and ultimate decision making.